What happens when you want to change final parenting orders? Hi, my name's Kirstin and I am a family lawyer at Solari & Stock. Today we'll be discussing how to vary final parenting orders. Now, generally a final parenting order will apply to a child until they reach 18 years of age. However, what happens if the child is very young when the orders are made? In reality, the child grows older and their needs change. The orders may no longer be reflective of their best interests. Now, this can be problematic if the original orders do not provide sufficient flexibility for the child going forward. In what circumstances, then, can a party apply to the court to vary those final parenting orders? The case of Rice and Asplund answers that question. I won't go into the facts of that case, but basically the full court determined that it won't review final parenting orders unless it is satisfied that there has been a significant change in circumstances since the original orders were made. Now, that is what is referred to as the threshold test. In that judgment, Chief Justice Attard said that the court should not lightly entertain an application to reopen parenting matters. To do so would be to invite endless litigation for change. There must be some evidence of a significant change in circumstances. What the court is saying there is that it's accepted that it's not in the best interests of a child for parties to constantly relitigate issues in parenting proceedings. What then is a significant change in circumstance? This will depend entirely on the facts of the case, but may include a party seeking to relocate with a child, the current orders were made without all of the relevant information before the court, one or more of the parties may have repartnered or remarried, or there may have been abuse of a child. So if the threshold test is met, the court will then consider what is in the best interests of the child and whether it is appropriate for a variation of the orders to be made and if that is desirable. It is important to note, however, that the court may still be reluctant to vary any final parenting orders even if there has been a significant change in circumstances. So alternatively, to avoid litigation, parties may choose to enter into a parenting plan to accord with what their parenting arrangements currently are or may be in the future. Keep watching for part 2 where we discuss parenting plans. Thank you and see you later.